If you think being polite and cooperative with the police will protect you, you're about to make the most expensive mistake of your life. Because most people don't get arrested because they're guilty, they get arrested because they talk. And I've seen 2-minute conversations with a cop turn into a search, handcuffs, and a court date, all because someone answered one question they didn't have to. I'm Jeff Hampton, the people's lawyer, and in this video, I'm breaking down every single trick cops use to get you talking, explaining, and consenting, and the exact words you can use to shut them down so that you don't accidentally help them build a case against you. If you've ever been pulled over for a traffic stop, it's important to know that cops have a gray bag of tricks that they can pull from to get you talking, and you end up giving consent so they can search your car. First off, it's important to know that cops may actually pull you over for a minor violation, even if they're really interested in something else. For example, they could stop you for a broken taillight, rolling through a stop sign, or maybe they think your license plate is out when their real reason they pulled you over was to investigate you for a more serious crime. These are called pretext stops. And in 1996, the Supreme Court held in Wren versus United States that a traffic stop is reasonable under the Fourth Amendment when police have probable cause to believe a traffic violation occurred, even if the officer's real motive was to investigate something else. A tiny violation can open the door to questioning, orders, and searches. So when you're pulled over, don't think you can talk your way out of it by being friendly and cooperative. The cop could be using your minor traffic violation as a way to trick you into saying something that could open the door to a bigger investigation. One of the first trick questions cops will ask you is, "Do you know why I stopped you?" Many people will answer, "Was I speeding or did I miss that stop sign?" If you admit to wrongdoing, now the officer doesn't have to prove it. You've just given yourself a ticket or worse. In 1984, the Supreme Court case of Berkmer versus McCarty held that routine roadside questioning during a typical traffic stop is generally not custodial interrogation for Miranda purposes. So, officers can ask questions and those answers can be used against you, even if you weren't Miranda'd. Never give the cops anything to use against you. So when the cops ask, "Do you know why I pulled you over?" simply say, "No, I don't. It was polite, but you offered nothing." Another most common trick question cops love to use is "Where you coming from?" or "Where you going?" This isn't friendly conversation. To answer these questions is to give cops a timeline for them to test against other information they're fishing for or to see if your story adds up. For example, "I just left my friend's house" will lead to further questions about what you were doing at your friend's house and whether or not maybe you were using drugs or alcohol. You're better off not narrating your night to the cops. Instead, you can say, "Officer, with all due respect, I will not answer that question." Now, what if the officer plays hardball and he doesn't like that? So he asks you to step out of the car. Now, many people feel, "I have the right to refuse. I don't have to get out of my car." But unfortunately, they can't. Based on the Supreme Court case of Pennsylvania versus Mims, cops can demand you to step out of the car in the name of officer safety, even if they don't have any real suspicion that you've committed a crime. Refusing this order, believe it or not, can result in cops pulling you out of your car, and you can end up being arrested for resisting arrest. However, once you're out of the car, watch out for more tricks because officers can claim you are acting nervously, or they can split up everyone to question you one by one, or they can take their time looking around the car for evidence that could be sitting in plain sight. If you're forced out of your car, protect yourself by locking your car doors and telling the officer you do not consent to a search. If you ever feel like you aren't able to leave the side of the road or the cops keep asking you questions to delay you being able to leave, this is where you simply say, "Officer, am I being detained?" If they don't give a clear answer, ask, "Am I free to go?" If the officers admit they have no reason to detain you, leave calmly. If they claim you are being detained, now you know. Exercise your right to remain silent, and you will not say anything further without your lawyer present. Now, how do you know if you're being detained? In the classic case of United States versus Menhall, the U.S. Supreme Court ruled that a person is considered seized or detained when, under all the circumstances, a reasonable person would not feel free to leave. That test is the legal backbone for why am I free to go matters, and why cops hope you don't ask that question so they can use it against you. So if the cops are being ambiguous with their answer and they don't clearly tell you that you are free to leave, it's time for you to exercise your right to remain silent and don't say a word unless your lawyer is present. So now we see how cops can trick you to get you talking, but cops also have their own bag of tricks so they can start searching your property. Perhaps the most common way for cops to get you to consent to search is to make the most casual request of saying, "Mind if I take a look?" And of course, they won't tell you you have a right to say no. Schnickloth versus Buamonte in United States versus Drayton both held that voluntary consent is a valid exception to the warrant requirement, and police are not required to advise people that they may refuse consent. And once you consent, you lose the ability to challenge that consent later in court, which is precisely why it's so important that when cops start that small talk and they ask questions like, "Mind if I take a look?" you look at the officer and you say, "Officer, I do not consent to any searches." And remember, if cops don't have a warrant, you always have a right to refuse any search. And some people only learn this the hard way. In 2018, an Arizona woman consented to a search during a traffic stop, and the cops found 55 lbs of marijuana in her trunk. Because she consented to that search, that evidence could now be used against her in court. But cops don't always ask. Sometimes they give orders and stare back at you. Statements like, "Pop the trunk." This sounds like a command you can't refuse, but that would be another one of their tricks. They are often trained to speak with authority to trigger your compliance. They are hoping to make it seem as though you don't have any choice, or to just agree to what they're demanding without even thinking. And if you go ahead and comply voluntarily, you can count on the police framing it as consent even if you felt pressured. Again, look right at the officer. And I know it may feel hard to do so, but look at the officer and say, "Officer, I do not consent to a search." But what if the cop doubles down, looks back at you, and now he claims, "I think I smell weed or a little alcohol in the car"? Watch out. This is just another one of their tricks to pressure you into consent to search. In the past, courts have treated odors as a basis for probable cause, but that standard has now changed in many states. The various levels of legalization for marijuana in different states have changed whether or not odor can be used as a basis to get into your vehicle in search. For example, the Illinois Supreme Court has said that the smell of marijuana alone is not enough for probable cause to search a vehicle, since cannabis possession can be lawful and odor doesn't automatically imply a crime. But either way, it's not worth it to argue with the cops here. If the cops want to search you or your car based on odor alone, you just stand firm on your rights and you say, "Officer, I do not consent to a search." Which leads us to the next trick cops love to use. If you don't comply with what they want, they'll now threaten you that they're going to get a warrant. Sometimes this is a bluff. Sometimes they think they can build probable cause. But either way, it's another trick meant to make you give up without forcing them to meet their legal standards. If the cops stare at you and threaten you with a warrant, just look right back at them and say, "Officer, I do not consent to a search." But what if cops then suddenly claim they already have a warrant and it's going to go harder for you if you don't cooperate? Well, watch out for this trick, because according to Bumper versus North Carolina, consent is not voluntary when it is given only after officers claim they already have a warrant. At this point, it is effectively submission to authority, not consent. This is the one warrant bluff line that courts take very seriously. But those are tricks cops use to search your vehicle. Now, what if they want to pat you down for weapons? Do they really need a warrant for that? This is where cops will ask you in advance if they can pat you down for weapons for their own safety's sake. Under the Supreme Court case of Terry versus Ohio, a police officer can briefly stop someone on reasonable suspicion and frisk for weapons only if they reasonably believe the person may be armed and dangerous. But what if the cops feel something else other than a weapon? Under the plane of view doctrine in Terry versus Ohio, cops could still seize any other illegal contraband only if it's immediately apparent that it's illegal. But here's the trick. Cops are always going to ask you for your consent because they're afraid they may not be able to navigate the legal minefield of establishing they have the legal basis to pat you down for weapons. So if you consent, you lower your ability to challenge that stop later, and you've fallen for another trick. So, while you may not be able to prevent the officer from performing the pat-down search on you, you can always make it clear where you stand and stand up for your legal rights by refusing consent to that search. Simply say, "I refuse consent to a search." And remember, this legal standard only allows them to do a pat-down of your outer clothing, and if they go deeper than your outer clothing, you now have a legal challenge in court. So, what if you don't fall for any of these police tricks and now all of a sudden the cops claim, since you're not cooperating, we're bringing a K9 out to sniff around your car? Most courts have ruled that a well-trained narcotics dog sniffing around a car during a lawful traffic stop doesn't technically count as a search. However, in the 2015 United States Supreme Court case of Rodriguez versus United States, the Supreme Court ruled that cops cannot extend a traffic stop just to make you wait around for a drug dog to show up. In other words, they can't drag their feet to make you wait around for a drug dog to show up when they don't have reasonable suspicion you've committed a crime. But this doesn't stop cops from using some of their tried and true tricks to keep you waiting around so that they can justify having the K9 come out. Tricks like doing a slow walk routine around your car looking for any type of equipment malfunctions. Or maybe they decided they want to keep you standing around asking you a bunch of irrelevant questions. Finally, another great trick they use is they'll claim they're still working to stop and looking into a few things while they wait for the K9 to show up. If you feel like this is happening, remember you have a constitutional right to not answer any questions. You have a right to exercise your right to an attorney. You also have your right to ask the officer, "Officer, am I being detained or am I free to leave?" This is really critical when it comes to drug dog searches because now you're creating a record and making it crystal clear you're not consenting to sitting around waiting, and you've started that clock of unreasonable time that's lapsing by when cops don't let you go. So, what if the cops now realize you're not going to fall for the drug dog trick, but they look over and see that you're holding a phone? And they may ask you the question, "Mind if I take a look at your phone real quick?" According to the Supreme Court case of Riley versus California, the court ruled specifically police need a search warrant in order to search the digital contents of your phone because the court said our cell phones inherently have a unique privacy interest because of all the data and all the important documents and information we keep on our phone. But this doesn't stop cops from using that old trick that they love to use by asking, "Hey, listen, if you'll just unlock your phone, I'll take a look so we can clear all this up and have you on your way." But in reality, cops are hoping you'll just unlock it because you will have now given them what they would normally have needed a warrant for. Never unlock your phone in front of a police officer without a lawyer. And equally more important, don't use biometrics on your phone. Courts have ruled that cops can literally force your finger or your face in front of that computer or onto the actual screen. And if that will unlock the phone, there is no Fifth Amendment right to protect cops from using something physical to gain access to the phone. So don't use any of these, and don't unlock the phone in front of a cop. But tricks don't just happen on the roadside. Cops have a handful of tricks they love to use when they come to your front door. The number one classic trick cops are trained to use when they want to get inside your home is to come by, knock on that front door, and just say, "Hello, sir. We're going around asking a few questions about some things that we heard about going on in the neighborhood, and we just wanted to talk for a minute." This is known as the old-fashioned knock and talk. The Supreme Court case of Florida versus Jardines explains that police officers generally have an implied license to approach a home's front door, knock, and attempt a conversation. But that same case of Jardines ruled that if police officers were to bring a drug dog into walking around your front door, smelling to see what's going on, that would be considered a search, and they must have a warrant. Under the Fourth Amendment, you have no responsibility whatsoever to ever open that front door when a police officer comes and knocks on your door. You legally have a right to completely ignore that police officer at the front door unless they claim they have a warrant. Your house is your castle, and you don't have to answer the door. If they have a warrant, they can prove it to you by showing it there at a window and making sure you see it, that it's signed by a judge and it's a valid warrant. If they don't have a warrant, you can literally keep the door shut, ignore them, and not say a word. So what if the old knock and talk doesn't work, and instead of saying they want to come in and talk, they decide, don't worry, we're just going to look around? This brings us to your Fourth Amendment right, that cops do not have a legal right to walk around what's known as the curtilage of your home to just snoop around and see whatever they can find. The Supreme Court case of Payton versus New York says that cops must have a warrant in order to enter into your home and look around. And they also must have a warrant if they want to search around the curtilage of your home, meaning the area uniquely and exactly precisely around the outside of your home. So they can't just go into your backyard and do whatever they want to do. They've got to have a warrant. So the trick here, saying, oh, we're just going to look around, is a way to get your attention and hopefully get you to come outside so now they can confront you. It's essentially a sneaky way to try to see if they can get your consent to do something they otherwise couldn't do. What do we say here? We stay inside our home. We talk through the door and say, "Officer, I do not consent to a search. Do you have a warrant?" So, what if they don't have a warrant, but now all of a sudden they claim they're there for a welfare check? They're there to check on your safety. This is known as a welfare check. But the Supreme Court ruled in Kigula versus Stroh that police using this community caretaking justification doesn't work in order for them to get into your home unless they use the emergency aid doctrine. Which means now if cops claim that, oh my goodness, I think this person's suicidal or there's some problem here, they can now use this doctrine under the Supreme Court law to allow them to get into your home without a warrant and then seek that legal justification after the fact. So, how do you stop cops from using this trick against you? Go to your door, but keep the door shut. If you can pull back a window and show the officer, "Officer, I am perfectly fine. There is nothing for you to check on. I am not in harm's way. I do not consent to search," and leave it at that. But what if you do everything right and lock down your constitutional rights inside your home? And then you're out in public walking around and the cops walk up and say, hey, you're not under arrest. We just want to talk. This is one of the areas I see many people fold like a cheap tent. A common misconception I see people have is that because an officer walked up and had what was known as a consensual encounter, that, hey, he didn't read me my rights, so this isn't really an interrogation and they can't use what I say against me. That's completely wrong. Any statement you make during a consensual encounter with a cop can be used against you and is absolutely admissible in court. It's only when you're in custody and detained and under interrogation do cops have an obligation to read you your Miranda rights. But cops, they don't expect you to know that. So they treat it as a nice little consensual encounter, hoping you'll volunteer information and they can twist and turn it and manipulate it into something that now could land you behind bars. So you choose to do the right thing. You look at that officer and you say, "Officer, I exercise my right to remain silent and I will not answer any questions unless my attorney is present." That's when cops pull the next trick out of their tool belt where they look at you and they say, "Well, listen, we're going to just continue to find you and approach you about this. If you'll just come down to the station, we can clear everything up." Going down to the station to clear things up is one of the most dangerous things you can do. In fact, clear things up is essentially code for, we believe you've done something wrong and we're putting you in a room and you're going to be outnumbered and outspoken to and out interrogated, and we're planning on getting evidence out of you. Even if you're in a situation where you can't leave and they're asking you questions, you can always memorize these words. I exercise my right to remain silent, and I will not answer a question unless my attorney is present. But remember, if you're going to stand up for your rights and you're going to exercise your rights, none of it will matter if you don't verbalize your rights. In the Supreme Court case of Burgess versus Tompkins, the Supreme Court says that your right to remain silent only works if you unambiguously invoke your right to remain silent. So if you choose to remain silent, that silence can actually be used against you. And to make matters worse, in Davis versus United States, the Supreme Court said that cops can continue to interrogate you, and they don't have to stop unless you unambiguously say you want a lawyer. So you must plainly state that you want your lawyer and then stop talking. Never say, I think I might need a lawyer, or maybe I should consider a lawyer. That won't work. You have to say very clearly, Officer, I exercise my right to remain silent. I will not speak unless I have my lawyer present. And remember, even after you invoked your right to a lawyer, if you keep talking, those words can still be used against you too. So stop talking. There is no such thing as being off the record. But even if you do exercise your right to remain silent here, you still gotta watch out for the good cop, bad cop trick. We've all seen it on TV. The bad cop comes in and threatens you with the worst case scenario and claims you're going to get the book thrown at you. Then the good cop magically walks in, says he's your best friend, and he wants to protect you from the bad cop. This trick is very effective because it makes you feel like you have a friend in the room, and you're a little afraid of the boogeyman who wants to throw the book at you. But remember, this is a trick, and these two cops are working together. Why are they allowed to do this? Well, under the Supreme Court case of Colorado versus Connolly, the Supreme Court emphasized that in order for a confession to be deemed involuntary under due process, there generally must be coercive political activity that overbears the will of the suspect. This means courts say they'll allow as much manipulation as possible by the police and deem it to be legal as long as it doesn't bleed over into the realm of coercion. Which brings me to the most common trick, and the trick I speak about on this channel all the time. Cops are legally allowed to lie to you. If you lie to the cops, you can be charged with false report to a peace officer, but cops can lie to you all the time. They can claim they found your fingerprints at the scene. They can turn around and say, "We already know your best buddy over here. He already told us you did it." In fact, Ted Bradford of Washington State sat in prison for over a decade after confessing to a crime he didn't commit because police had lied to him. They claimed they had DNA evidence when they didn't, and that scared Ted, so he admitted to something he didn't do. The most common example of this is you may try to explain away evidence that wasn't even real. For example, maybe you were at the scene earlier in the day and then cops claim that they have your fingerprints there, which might exist, but now you're trying to explain all these reasons why they may have your fingerprints to begin with. Which now what do? You put yourself at the scene. You become a suspect. Cops use lies because they know it leads to people talking, which then can be used as evidence against them in court. And one of their favorite lies they love to use is to make false promises to you. Cops love to extend interrogations for hours, sometimes days, and then promise you relief if you'll just start talking to them and tell them what they want. Many cops are notorious for promising juveniles and younger suspects the opportunity to just go home if they'll tell them what they want to hear. Never believe a single promise a cop makes to you. They're not lawyers, they're not the judge, and they're certainly not prosecutors. So why do cops use these tricks? Because cops know they can use your normal human behavior to manipulate you into doing what they want. They rely on their authority and your desire to be polite, helpful, and cooperative. They've been trained to get information out of you without even realizing you're giving it. And cops love to use the common phrase that if you're innocent, you have nothing to hide. And innocent people always tell everything when asked by cops. I mean, after all, it's only the guilty people that stay quiet or push back. But thankfully, the United States Constitution says standing up for your rights doesn't make you guilty. In fact, our Constitution says that assuming the police are on your side probably makes you a lot more vulnerable. In reality, the police's job is not just to protect and serve. It is their job to try to gather evidence and point a finger. The safest move you can always make, And the magic word you should always say is, "Officer, I exercise my right to remain silent. I do not consent to searches, and I will not answer questions unless my attorney is present." Speaking of tricks, do you know cops have a whole new bag of tricks if they pull you over and suspect you of DWI? Check out this next video where I break down 5 favorite tricks cops love to use during DWI stops and what you can do to protect yourself.